Hey, welcome back to Business 150, Introduction to Management. We have just a couple more videos in this module, and this one we're looking at a very big topic, and this is of course just a video overview of this topic. This is an enormous one, you can see from the title slide. The legal environment of human resource management. The legal constraints put on employment and what employers can and cannot do in terms of interacting with their employees. This is, like I said, a huge topic, and so we hope that after this brief video, you'll at least be able to summarize some of the major laws that affect employment decisions. And as I mentioned in the previous video, when you talk about compensation, you're talking about an enormous discipline with a lot of different best practices and rules, and we just lightly touched on some of them. And in this video, of course, there are an enormous rubric of federal and state and local legislative statutes that affect employment, what you're able to do in terms of candidating, recruiting, interviewing, assessing applications, the kinds of questions you're allowed to ask, and then after someone becomes your employee, what you're allowed to do in terms of compensation, in terms of reasons for terminating employment, all those kinds of things. We're just going to look at a very brief overview of the complexion of this. So, the textbook would tell us that over the last several decades, regulation of HR activities has increased in terms of both areas covered and the number of laws passed. That is an understatement. Now, the legal environment of HRM requires that whoever is in charge of your HR really should be completely up to date on what is going on and well trained and educated formally to make sure that your firm is completely compliant as much as humanly possible with contemporary legal statute. You can see there in the second bullet point, equal employment opportunity laws are designed to protect individuals from unfair discrimination in employment decisions based on race, sex, age, national origin, religion, disability, pregnancy, and there are, of course, several more protected categories that employers are not allowed to exercise bias or unfair discrimination based upon those dimensions. The National Labor Relations Act of 1935, going all the way back to 1935, established the right of workers to organize unions and bargain collectively with employers over wages, hours, and terms and conditions of employment. Now, more on unions in this slide. You can see here unions are employee organizations that work with employers to achieve better pay, better hours, and better working conditions. Unions and employers engage in collective bargaining, a process of negotiation through which representatives of management and representatives from the union reach an agreement regarding pay, working conditions, hours, and those other things. Other major issues today include employment health and safety, healthcare benefits, labor laws, discrimination based on sexual orientation. I would tell you that when it comes to the topic of unions, unions are still a durable part of the employment scene in many different industries. Everything from labor-intensive industries like shipping, like construction, even package delivery. The Teamsters Union is still a durable part of United Parcel Service. As well as when most colleges and universities, teachers are organized in terms of unions. I've been in a labor union both at the Cal State system as well as here at College of Marin. Unions fight hard to protect the rights of instructors. And this isn't to say that any particular college or university administration is acting in bad faith or against what's good for instructors. Nevertheless, it helps to have someone who is exclusively representing instructor rights to be able to have a voice in the matter on these kinds of things. And so, depending on the industry you're talking about, unions may have a bigger or smaller role in your employment, but they have traditionally proven to be an important and significant part of the bargaining process. And let's be fair, they also have proven from time to time throughout history to actually impede progress and in the fight to keep the status quo have really worked in the counter to the best interests of both employees that they supposedly represent, as well as the organization, progress of the organization. So it's a thorny topic. More on this in the text, and more, of course, if you want to read. Just be careful you read both sides of the story on this. There is a valuable role that unions serve and have served, and there have been some ways where they could have done better and really have operated at cross purposes. So as much as I can say, I think in this particular lecture on this topic, this being an overview class, but there are wholesale detailed studies about the history of unions, whether or not they have been a good or a not so good thing in the employment landscape. Here you see represented from the textbook some major examples of federal and state laws that affect human resource management. You can see them here. The first group, equal employment opportunity laws, dating all the way back to the civil rights era of the 60s, all the way up to the 90s with the Americans with Disabilities Act. Simply federal law that has attempted to maintain the posture of equal opportunity for all protected classes. And then you see that the second block, health and safety laws, including OSHA of 1970, the Occupational Safety and Health Act, as well as Workman's Comp and Patient Protection and the Affordable Health Care Act of 2010, all of these attempting to advance and protect the health and safety of employees in the federal and state marketplace. And then finally, labor management law. You see 3 statutes cited there, dating back to the 30s and 40s, about organization and the right to organize as a union, as well as minimum wages, which are then amended by states, right, as well as the standards and oversight for what constitutes child labor and these kinds of things. These are all just examples of the great big broad brush swatches of legal statute that affects HR decisions. And there are more. Again, these are just representative of the ways that government seeks to make sure that employment is generally handled in a fair and non-discriminatory way. So when you are trying to navigate through these things from a managerial perspective, you have to trust that your HR department is adequately trained, and where there are compliance issues, that as a company you are trying to deal with those things immediately and proactively. Because quite frankly, labor lawsuits and employment lawsuits can put a company in a very bad position, and so you want to avoid those and act in good faith as much as possible. One might suggest that with the sheer volume of labor law that's out there, it's really difficult for any firm to be 100% completely compliant every single day of the year. And all that really is the best practice is when you realize, when it comes to your attention, that you have some exposure because inadvertently you are not in complete compliance, that you proactively fix that stuff as quickly as you possibly can. All right. So we hope that this has provided at least a landscape, a quick view of what some of the major laws that will affect your HR department and employment and hiring decisions, the kinds of things that you need to be aware of, that yes, the federal government has a say-so, and there are real penalties for violating some of these statutes. So we hope that helps, and we will see you in the next and last lecture of Module 9.